Oh, counsel, you're on the other side.
But that's my good side there.
All right, if we could have Mr. Esquivel come up, please. Ms. Abrams,
That's right.
on this case, the state is asking to be withdrawn. What's going on?
Under the agreement, Your Honor, that his conditions would be altered and that for supportive outpatient treatment. To add support outpatient treatment.
All right, so Mr. Esquivel, what's going on?
Well, yeah, he came up, Dirty Judge, June, actually, I want to say April, June, and August.
All right, is it for alcohol or something else?
Marijuana. And then he came up negative, August, and they've been testing him every 2 weeks, and that's negative as well.
All right. So do you all want to see what will happen with the remaining UA testing before there's added conditions or no?
I think it's be good to give him opportunity to hopefully get clean, have to use. And our position is it has realigned, like the court has his full attention. This is just going to show the court that he's in line because we've already had several negatives.
Okay.
I think the last one was December 3rd or January 3rd.
My last drug test was December 31st.
That's correct, Your Honor. That was his last drug test. He did come back negative.
So Judge, he was the month of December, he submitted 3 drug tests, all of them were negative. Before the state was going to withdraw, what's listed on the court summary is for him to amend the recommendation was to amend for MRT. After state and defense spoke, I believe they come up with the agreement for supportive outpatient treatment, which I do not have an issue with.
All right, so do y'all want supportive outpatient treatment or do y'all want him to do sober support meetings?
Because with that said, I don't know the distinction. I do know he's self-employed welder. So the only thing we're concerned about is the time.
All right, so sober support meetings are AA meetings. They call them sober support meetings now, but it's the same thing.
I would personally support treatment so they can get the counseling that I think he needs, but if your Honor feels that sober support meetings is better for him, then I'll just let them.
Well, he said his employment. I don't know. What are your work hours?
We from 7 to 6, not available. I have sole custody of my son. His mother passed away. So it's hard for me to have time in that news. And you track your work takes you outside of Bear County sometimes, some days? Sometimes near Bernie.
So he's saying he works from 7 to 6 and then he has full custody of his son.
Supportive outpatient.
All right, will they be able to accommodate his work schedule?
Now, watch the balancing act. The court, the defendant's employment, and parental responsibilities. This is real life colliding with legal mandates. The judge isn't just rubber stamping. She's weighing if the treatment plan is actually feasible given his 7 to 6 work schedule and full custody of his son. It's a reminder that justice isn't just rules, it's real-world logistics.
Judge will have to figure it out.
Okay, so the motion to withdraw is going to be granted. I'm going to alter and amend as agreed by parties to supportive outpatient treatment.
Thank you, Judge.
All right, thank you. Once you sign the documents, you're excused.
And Judge, I'm on Mr. Esquivel's bond. Will that be removed today? The bond, requirement?
You can ask the clerks to do that. That's not in my wheel.
I didn't know if that was by the mighty pen. Thank you, Your Honor.
Sure. Raymond Diaz?
Yes.
Pick up real loud.
Raymond Diaz.
No,
when you
ask a question. Sorry, but you're doing great.
All right, so today's plea deadline date.
State has extended an offer. We have made sure that the defense has received all of discovery. However, we did subpoena some therapy records. we heard back from the therapy institution that there were no records found. We believe we got the wrong name. Needed to correct that. I believe the defense was one of those records.
Well, I just want to see what's in there. If they're going to subpoena them, first of all, Your Honor. And then second of all, the discovery, I believe it's been uploaded on the state's end to e-discovery, but not on my end. So I tendered a flash drive in the off docket period and I received that back, I think, late last week. I have not had the opportunity to go over it with my client. So what I would ask, and I believe the state's okay with it, is just extending the plea deadline one more setting to figure out what we're going to do.
I'm typing things in that you said, so that's why
Oh, wow.
there's a gap.
Okay.
All right, Ms. Ferguson.
Okay.
Put this for a plea deadline date and a jury trial. How long do y'all expect this trial to last?
Stateside 2 days.
All right, Norma, you can put this sometime in March. If y'all will confer on the date,
Oh, yeah, of
Yes.
course.
and if you'll have a seat, he's going to confirm the date and counsel for jury trial, 72 hours to do the clothing exchange.
I'll make sure.
All right, thank you.
No short,
Thank you.
anything weird like.
Okay,
Thank you.
Danny Rivas.
Okay.
Hello. Hi, you were late for court today. What happened?
Not dying outside.
Okay, so you need to make sure you account for that. All right, so we're scheduled for jury trials?
Yes, Judge, we're ready.
Okay. State,
Yeah.
who's with the state on Danny Rivas? How long do you expect this trial to last?
2 days, 2.5.
All right, do y'all want to do jury selection on Thursday?
Sure, that works.
All right, Norma, recall this back for Thursday for jury trial.
Yep.
All right, we'll see you then.
Thank you, Judge. Is that in the morning or in the afternoon?
We'll do jury selection in the afternoon.
Okay.
All right, thank you.
Thank you, Your Honor.
Nicholas Kionis. Yep, Nicholas.
Mike, you know, sorry, not here. Good morning, Your Honor.
Good morning. How are you doing today?
They were sick.
Oh, well, we don't want you here if you're sick.
I'm out of frame now, so.
All right, so what is happening with his case?
Judge, we've conferred, we've been given an offer. The offer's been rejected.
Mhm.
So we request a jury trial,
All right, how long will this trial last?
2 days.
All right, I don't want to put you all to trial today since he's sick. Are you okay with that, counsel?
I'm fine with that.
All right, Ms. Ferguson, I need a jury trial date, 2 days. And you can do a quick turnaround on this one. I'm sorry, when?
March 17th, once a week.
Well, is that during spring break time?
I'm not going anywhere for spring break, so.
Oh, okay. All right, March 17th. And I need an acknowledgement of discovery completed.
Yes, ma'am, we'll do that right now.
All right, thank you.
Thank you.
Are we doing spring break, Judge?
All right, Billy Joe Hernandez. All right, are you all ready to proceed on the motion?
Yes, Judge.
Court is calling 2022 CR 7314 State versus Billy Hernandez. Can I have parties announced for the record for the state?
Valerie Headland for Billy Hernandez.
And are you Mr. Hernandez? Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it? Are you the same Billy Hernandez who was placed on community supervision in 2022 CR 7314 for the offense of possession of a controlled substance penalty group 1 to 4 grams on October 25th, 2022 for a term of 6 years and extended for 2 years? Is that you?
Yes, sir.
All right, state.
Violating condition number 2, on or about the 4th day of June 2025 in Bear County, Texas, the defendant Billy Hernandez did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
Violating condition number 40, on or about the 4th day of November 2025 in Bear County, Texas, defendant Billy Hernandez did then and there fail to comply with the rules, regulations, or instructions of the Dare County Supervision and Corrections Department Substance Abuse Felony Punishment Facility Continuum of Care Treatment Plan, in that the defendant failed to participate in safe P continuum of care in violation of condition number 3.
How do you plead to that? True or not true?
State will waive the remaining.
Any objection?
No.
Did you understand by pleading true to violations 2 and 40, the court could find it true, grant the motion, and sentence you up to 6 years in the prison?
Yes, Your Honor.
And up to there's no fine. Knowing that, do you still wish to plead true to violations 2 and 40? Court will find 2 and 40 true. Is there a proposed agreement?
Yes, Judge, proposed agreement is to deny state's motion, continue on probation, alter and amend to resend Mr. Hernandez to safety, preferably relapse track if available.
All right. Mr. Hernandez. It appears to the court that maybe you don't want to be on probation because you were ordered to go to safety and you refused. So I don't know why I should, order safety again. How old are you? All right. So it's not as though sometimes when you have younger people or you're dealing with children, they don't realize all the consequences of their actions. So you give them an opportunity to reevaluate. I'm trying to figure out why I should give you an opportunity to reevaluate when that's what was ordered and you didn't do it. And the fact that you've been extended for 2 years tells me we've been here before on a previous motion to revoke. Otherwise, normally there would not be an extension. So I don't understand why I should continue you.
I'd just like to continue my recovery. I was just set back on the triggers that I should have been aware of.
And Judge, just for the record too, he did the actual full safe P. It was aftercare that he got discharged from. He did have a heroin addiction and went through the Suboxone treatment. That was years, I don't know how long ago, but he got clean off heroin. He hasn't used heroin. I think his couple of positives were meth, and we've had discussions about that as well. And he really does want to go back. Excuse me. And he's never been to TDC. He doesn't have any felony convictions. And I think it's minor misdemeanor prior history. So he's asking for a second chance and is willing to participate in the program, right?
Probation.
Yes, Judge.
So is he a good candidate to be continued on probation? He's been on probation since 2022. And he's already been extended for previous violation.
This is his second MTR. He completed 177 days of safe P, and he just didn't follow through with his aftercare program, Judge, and that is what kicked him out.
All right, this is what I'm going to do. I don't know if you're appropriate for probation or not. Well, I shouldn't say that. I believe that you should be revoked, right?
Boom. This is the moment of truth. Hernandez faces a classic judicial crossroads: straight prison or a structured second chance through the safe relapse program. Listen closely to the judge. No sugarcoating, no wiggle room. This is where courtroom drama hits peak tension, and you can almost feel the weight of every decision he's ever made bearing down.
But I don't have a crystal ball. Maybe I'm wrong. Maybe you have changed and maybe you're ready to complete everything and get your life together. So I'm going to give you a choice. These are your only two choices. There are no other choices, so don't ask me for a third option, right? Your choice will be, I will revoke you. I will sentence you to 4 years in the prison. You'll receive credit because legally you're required to receive credit for the time you completed safe P. As a part of sentencing you, I'll ask that you be placed in the therapeutic community. Otherwise, I will continue you It's gonna be the Safe P relapse program. You gotta remain in custody till transfer. And I'll also ask that he be considered for felony drug court. So which do you prefer?
Committed to continue?
All right. And is there any gang affiliation?
No, I asked him the same thing, Judge.
Okay. All right, this is what the court will do. The court is going to deny the motion, alternate amend conditions to, I'll state you may be excused, to include a Safe P relapse program and a referral to felony drug court, and that's to be done in custody. And probation, did we do a gang evaluation for him?
Judge, I would have to check,
And we'll do a gang evaluation if not previously completed.
It mentions it in the summary, Judge, but it doesn't say like that it was completed or what result was found, and it's not tagged in his court documents that I could see, so.
Okay. Is there anything else you need from the court in order to be successful? Right, and then upon release, I'm gonna ask that he do daily sober support meetings. And those are your NAAA meetings. All right, we can go off the record. Here's the thing. You're looking at 6 years in the prison. If you continue to use, only one or two things gonna end up happening. One, you may end up going to prison. Or two, the last time you use may be the last time you use, and then somebody's gonna have to identify you. I know you don't want that. My understanding, based from everything I've read, addiction is hard to conquer. But in this court, and your attorney will tell you, if you feel as though you're going to use, all you have to do is pick up the phone and call probation. And what will end up happening, oh, the last one, hey, what will end up happening is probation. Sometimes they will contact me and say, hey, we got a phone call. He's thinking about using it. Then you know what I would usually do? Have you come in, ask you, how can we help you maintain your sobriety? But if you disappear, if you just give in and use, that's going to be a problem. You understand? All right, good luck to you.
Thank you, Judge.
Charles Atwell. Hello, Mr. Atwell. How are you doing?
I'm doing fine yourself.
Oh, I'm doing great. I can't complain.
So this is actually my first appearance with Mr. Atwell. They don't actually have a file, so I haven't received an offer yet, but it's our first appearance.
All right. So, Mr. Atwell, what we're going to do, we're going to recall this case for 30 days. And at that time, everybody should have their discovery and the state should be prepared to tender an offer. You understand? Do you have any questions about anything?
Is there any bond?
All right, with regards to bond issues, motions will have to be filed. And so that can be heard quickly. I'll make sure that it's sent to a Judge Nahara or either Judge Halstead to hear that.
30 days.
Well, your attorney can file that before then, and we'll get it set as soon as it's filed. Okay, any other questions? Right, but on all bond issues, it's required by law that we have a hearing. Okay, and I can't have a hearing unless I have something filed before me, okay? All right, Ms. Ferguson, I need a 30-day reset.
February 17th.
All right, so in this court, you're gonna be back on February 7th. I'm sorry, you said 17th?
Yes, ma'am.
So what's gonna happen on February 17th? Your attorney will let me know whether or not he's received all the information he's required to receive from the state. The state will tender him an offer. And then at the next setting, if y'all don't come to an agreement on February 17th, I and this court set it for plea deadline date. So that will be the last date for maybe you ought to work out something if you can, okay?
So we could take care of this all on I'll say like it.
Oh, it depends on you and your attorney. Okay. And then with regards to any bond issues, your attorney will file a motion and we'll get that heard as quickly as possible. All right, any other questions? All right, thank you.
Thank you, Judge.
You're welcome. All right, the court is calling 2025 CR 004783 State versus Emmanuel Rios. Could I have parties announced for the record?
Brandon Prada with the state.
Daniel Vella on behalf of Mr. Rios, Your Honor.
And are you Mr. Rios?
Yes, ma'am.
Counsel, you've received all discovery. Did you review it with your client?
Yes, I did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Rios, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, I believe we'll be proceeding on the lesser included offense of deadly conduct.
Any objection?
No, Your Honor.
Mr. Rios, did you review the court's admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand the state is proceeding on the lesser included offense of deadly conduct as a Class A misdemeanor?
Yes, ma'am.
Range of punishment is up to a $4,000 fine and up to 1 year in the Bexar County Jail. If you have a plea with the state, the court does not have to follow that plea. If for any reason the court does not follow that plea and gives you more than you bargained for, the fact that you entered the plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Rios, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the lesser included offense of deadly conduct. They're asking that your fine be assessed at $1,000 and they're recommending deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Here's a masterclass in judicial guidance. The judge is not just enforcing rules, she's mentoring. Pick up the phone and call Probation is more than advice, it's a lifeline. Addiction is complicated, but the court is actively giving the defendant tools to stay alive and out of prison. This is a rare glimpse of human empathy inside a legal framework.
Yes, Your Honor.
State.
It is, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be assessed at 2 years. There be 100 hours of community supervision. There should be no contact with Mr. Guerra, Ms. Mendiola, Ms. Rios, the hostility management course, and the MRT. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Judge, the state offers state exhibit number 1 and all of its attachments.
No objection.
All right, and state, have you spoken with the complainants?
I believe that we have, Judge.
All right, thank you. You may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent? Do you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
Yes, Your Honor.
All right, so how's your relationship with Lucinda?
This is my sister.
Yeah, I mean,
We're pretty close.
they're asking for no contact.
I was going to address that, Your Honor. Maybe that I've conferred with the state on that. They're willing to take that apart
take that part off as one of the recommended conditions.
All right, so here's the thing. This is the way the court handles no contact. No contact. Your sister will need to provide a letter or talk with probation before I consider lifting the no contact order.
Yes.
Right. So why did this happen?
It was a situation with my sister and her boyfriend at the time.
Mhm.
Um,
And who's your sister's boyfriend?
it's Mr. Guerra, Mr. Samuel Guerra.
Okay.
And I guess they were having a lot of their own differences. From my understanding, he went to her house and vandalized a few things,
Mhm.
stole a few of her properties.
And so did your sister call you over? All right. So you went over to her place?
No, no. I was driving to pick up my daughter from school, and I intentionally drive on the because Mr. Guerra lives in front of my daughter's previous school.
Mhm.
So I drive on the opposite side because they always have problems fighting, so I try to stay out of it.
Oh, no. I see. I mixed up the names a little bit. Your sister let you know that her boyfriend or ex had taken his belongings and left the residence with her weapon.
Yes.
Ah, okay.
He had messed up a few things there and
All right, now I know what's going on. All right, so are you employed?
yes, ma'am.
And what do you do?
I'm a janitor.
Okay. Do you have children?
Yes, ma'am.
What are their ages?
8 years old. I just have one daughter.
Okay, and do your children live with you?
Yes.
All right,
As a provider.
Hmm?
I'm just the sole provider of my daughter.
okay. All right, this is what the court is going to do. The court is going to sentence you to 1 year deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors, field visits 1 time per month for 2 months, 100 hours of community supervision. 100 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the community service hours will be deemed satisfied. There's to be no contact with Samuel Guerra, Amanda Mendiola, Lucinda Rios. With regards to Lucinda, the court will consider removing the no contact order upon request from Ms. Rios. All right, probation, is there anything else?
No, ma'am.
Is there anything else you need from the court in order to be successful?
Thank you.
You're welcome. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Counsel, is there anything else?
There is one more matter, Your Honor.
Yes.
And that is, he's been, since his arrest, he's been on a GPS.
State any objections to the removal of GPS?
Okay.
All right. And GPS is to be removed.
Thank you, Your Honor.
All right. We can go off the record. Here's the thing, in this court, to be successful on probation, communication is key. Make sure you stay in contact with probation. If there's an issue, let them know about it and do not contact the complainant. And before helping your sister again and interfering, you need to evaluate all the consequences. You understand?
Yes, ma'am. I learned a lot.
All right, because that day you could have been killed, then your child wouldn't have the father, you know? All right, good luck to you. You're welcome. Who's next?